there is something worse than a king.
Of course there is. There are lots of kings ruling lots of perfectly democratic countries right now in Europe. Our tradition, coming from the Declaration of Independence, holds that there is natural law, but also British law, which George III violated, and that was the basis for our rebellion. It's not our tradition that there are people who can be above the law as such. The basis of the Constitution is that every office is given a firm basis of regulation. There's nothing in the Constitution which suggests that there are people, whatever office they might hold, who can be above the Constitution, outside of the rule of law. And that is the danger, which I think hasn't been quite specifically expressed here, that the idea of immunity means that there could be a person who is outside the whole system.
Supreme Court arguments fascinate me because they are limited, of course, to legal practitioners, and yet they involve so much more, so much of the time. Sometimes it involves science, sometimes it involves medical science, sometimes it involves history, obviously a lot of history, American history, other history. And so I'm often wondering what people who have a lot of the authority that the Supreme Court wishes it had, what their reaction is to Supreme Court arguments, which is why I'm thrilled to have you here tonight. And I'm just wondering, what was going through your mind as a historian as you were listening to it? What did you wish you could have told the court if you had a chance?
Well, very basic points. Number one, in holding a hearing on the idea of immunity, you're calling the concept into existence where it hadn't existed before. Number two, the U.S. history point would be, if you are a textualist or something like that, there is nothing like immunity in the text of the Constitution. But number three, most fundamentally, what the history of comparative law teaches us is that there is a tradition in which you say the Constitution is just there for us to wait and find out who is going to break it, and then we're going to endorse that person and give them special rights. And that tradition, again, this is history of comparative law, is precisely the Nazi tradition. And this is what worries me, that on January 6, 2021, and the weeks before that, we encountered an individual who tried to put himself above the law, and now we're flirting with the idea that perhaps that might be all right.
Yeah, that's one of the things they never do is look beyond the narrow borders of American law to figure out their own guidance forward.
And I mean, I think this is a very good example of how this is a mistake. If you read the 193 pages or whatever it was of that hearing, you find a lot of backing and forthing, but you find no real conceptual challenges except by counsel and a couple of the justices to the idea that there is such a thing as this sort of personal immunity. And in our traditions, either in the Constitution or not, but in other traditions, it's something that you're drawn by. You celebrate it. You find that person who will break the law, and that person becomes the leader. That's precisely the definition of the fascist leader, the person who is outside the law. And so in this, as in a lot of other cases, I sometimes worry that Americans don't really see what they're flirting with because we're not looking around.